File. Where's the files? On the record in the matter of the people of the city of Lansing versus John Vu. Mr. Vu, can you unmute your device?
Yes.
Okay, today's the date set for an arraignment on a probation violation. I have a request and summons for probation violation that alleges that you violated the terms and conditions of your probation status by committing the following technical violations. It says that you tested positive for alcohol with an ETG of 718 nanogram per milliliter at EverHealth back on October 2nd, 2024. And so you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. You have the right to have the prosecution and the probation department put forth evidence that would establish that you in fact violated the terms of your probation as alleged. If you're found to be in violation of your probation can be extended. You can be sentenced to any term of jail time, and you also could have a additional oversight mechanisms put in place, including scram or sober link testing. Do you understand that?
Yes.
Did you want to request an attorney to represent you?
Yes.
Okay, I'm going to enter a plea of not guilty on the violation. We'll set this for a hearing. You need to appear in person.
November 4th.
November 4th at 1:15.
Okay.
Hang tight. When Ms. Sutter is available, I'll get you in a private meeting room with her so she can get some information from you, okay?
Okay.
Thank you. Noah Kane? Is Noah Kane?
She's in the breakout room speaking with him now.
Oh, he said he didn't want to go to Gwen's house. Did he change his mind?
I went to talk to him and then he said, I want.
Oh,
They both do.
did it let you turn that down?
Sorry.
Did it let you turn that down?
Had a dial on it to go to cooler, so I turned it to cooler.
Okay, is Ellen Boss in custody or something?
Ellen Boss is not.
He was not last I checked, Your Honor.
So you felt okay.
Yes.
Okay, on the record, I don't see Kane here. Is he in the breakout room?
He's on
James.
Zoom, Your Honor.
Okay. Mr. Kane, please start your video. On the record in the matter or matters of the people of the city of Lansing versus Noah Dakota Kane, 24L2885421 and 24L2890581. Appearance, please.
Brandon Waddell, Deputy City Attorney for the City of Lansing.
Public Defender Lauren Sutter. Mr. King previously declined a public defender. He changed this morning, and so I just finished speaking with him. I've taken an application from him. I've also submitted some information to Mr. Waddell for today.
Okay, we'll reset these matters. November 4th at 10. You have any questions today, Mr. Kane?
No, so I have a new court date for you said November 4th at 10.
November 4th at 10 a.m., correct.
Okay, yeah, I have no other questions.
Okay, you're all set for today.
All right, thank you.
You're welcome. I don't know where Mr. Allen Ross is. We will issue a bench warrant. Did it let you turn that to cool at all?
Yeah, it was on warmer. I turned it to, well, I don't know if it's gonna do anything, but I just sent an email.
You have an interpreter here? No interpreter? What about Raha and Vimana?
He is here.
But no interpreter?
No one heard.
That's Rwanda. They requested an interpreter? I see it was. You have to reset him. You've not been able to speak to him, I'm assuming.
Mr. King,
Yeah, we'll have to reset because he needs a Rwanda interpreter. November 4th. November 4th at 10. He's all set. Oh, I just want to know if he under.
I said just for me.
Oh, okay. I
He
didn't know.
does have a friend who's able to tell him.
Okay. On the record in the matter, the people of the city of Lansing versus Alejandro Martinez, 24-02697, council appearance.
Brandon Waddell, Deputy City Attorney in the City of Lansing.
And I'll be in here again, Your Honor. Assistant Public Defender Lauren Sutter. My understanding is that Mr. Martinez had also previously declined a public defender. Mr. Waddell advised me that he logged in to speak with Mr. Martinez, and Mr. Martinez had changed his mind regarding representation. I haven't been able to speak with him yet, but I will be seeking an adjournment so I can take an application with him.
Okay, it did appear that he was in the breakout room, but I tried to bring him back and it didn't let him come back.
It's possible. I was in with Mr. Kane, so I don't know if Mr. Martinez is another one waiting for me, but when Mr. Kane got called, I just came in here.
Okay, finally give him a date. November 4th at 10. And then Mr. Yu needs to meet with you
Yes, Your Honor.
once you're available. You representing Michaela Orient. Okay, these are numbers 24-02800 and 2803, City of Lansing versus Michaela Orient. Appearances, please.
Brandon Waddell, would have to see in Lansing.
Assistant Public Defender Lauren Sutter on behalf of Ms. Oriens, and Your Honor, just for some transparency here, I've been unable to speak with Ms. Oriens prior to the hearing. I haven't met her
Okay, we have two files here. One is failure to stop or identify after accident, and then suspended drive. Was there an offer that was extended on this yet?
There was not an offer made yet.
Okay. Or allowing a suspended revoked person to operate. Terry, Mr. Defend, someone else?
I believe that's why I need to speak with Your Honor in terms of getting applications done and then just meeting the representatives. Mr. Jenkins is here and he is ready to go.
Okay,
I believe that's all my people here.
okay, we'll call Jenkins and then you can go speak with whoever you need to speak to. City of Lansing versus Chataze Jenkins, 24-02706, appearance case.
Waddell, Deputy City Attorney on behalf of the City of Lansing.
Good morning or good afternoon, Your Honor. Assistant Public Defender Warren Sutter, appearing on behalf of Mr. Jenkins, who is standing to my right.
Okay, so Jenkins has been operating while intoxicated, 0.17 or higher, failure to stop after an accident. How are we proceeding on this?
Your Honor, we believe we'd like, the court agrees to adjourn in order for Mr. Jenkins to take a substance assessment before proceeding with any offers.
60 days.
If I may briefly, I am slightly concerned with 30 days, given the backlog of the substance locations in the city. Would the court allow 45 to 60 for him to do that?
Well, what my concerns are is I always do 30, because then they need to tell us that they actually made an appointment,
Fair enough, Your Honor.
and then I can reset it.
Fair enough, Your Honor.
The 25th.
The 25th at 10, and then if you get an appointment, obviously, you call this week, you get scheduled, and it's beyond that. Just let your attorney know. She can email my staff and we can get you a new date, okay? Do you have any questions? Any additional matters for the record?
Your Honor.
Nothing further.
Okay, we'll get you a notice.
Thank you.
You're welcome. Jesus. What's the film like in Florida to swear? We might be switching. Okay, I guess we start over on here. I think that's all I have for ordinances.
I think so, Your Honor. I'll hop back in a breakout room and do some intakes with some folks.
Thank you.
And just, did the court already arrange Mr. Lewis and?
Not guilty, he wants court appointed counsel.
Understood,
It's
Your Honor.
for-
Mind if I get the date from this hearing?
The fourth, I think.
Right.
Is what? For Mr. View,
For it's a Monday.
November 4th
At
at 1:15.
Thank you very much. Appreciate it.
Thank you, Your Honor.
Thank you.
Yeah, see ya. Have a good one.
File disappeared. Are you in bench? Yeah, wait a minute, I was. I'm like, what's going on? Yeah, another one just disappeared. Okay, there it goes. Sorry. They won't let me go into. Huh? My base is just giving me a problem. What's the matter?
The email, she just replied. I need it.
Well, this is not a layering of clothes issue, right?
You might have to take.
Are you able to open that courtroom door? James Trotter present.
No.
James Trotter is
He's
present.
on Zoom.
Yes, I'm here.
Okay, on the record, in the matter of Case Credit Union versus James Trotter Jr., 23-06178, council appearance.
Good afternoon, Your Honor. John Hintz appearing for the Plaintiff Case Credit Union.
Okay. And James Trotter is present today via Zoom today with the date that was set for hearing. And this was for a motion or an objection to an installment payment order. Mr. Hintz, did you all speak privately at all?
No, we have not, Your Honor. If we could, if you would put us into a breakout room, I promise we'll be direct and to the point. We won't take long, and then we'll come right back in.
Okay, let me see. Let me put you in. Room 2. Mr. Martinez?
Yes, ma'am.
Your matter was scheduled for a new date because you requested an attorney today. Is that correct?
Yes, ma'am.
Okay, so we set it for November 4th, what's it,
10.
at 10 o'clock, okay?
November 4th at 10 o'clock.
Correct.
Okay, November 4th, 10 o'clock. All right. Would this be through Zoom or would this be in person?
You can still appear via Zoom.
All right. And would that would be the same Zoom code, the same meeting code?
That's correct.
Okay.
Thank
All
you.
right. No problem. You have a nice day.
Thank you.
No problem.
This is Teresa Scott versus Dice Auto Sales, 24-01412, council appearance.
Good afternoon, Your Honor. Brent Cradiville representing Dice Auto.
Okay, ma'am, what's your name?
Teresa Scott.
Okay, this is a matter set for motion to set aside, that is a default judgment. Let's see. Is it supposed to be numbers? I only have Witherspoon, Trotter, and Flores. It's what? I see the page. I don't know, I don't know where it's coming from me. Oh, wait, okay, fresh. info. Okay. I don't- Okay, there was a default judgment. Okay, Mr. Credible, you represent the defendant in this matter, Dice Auto Sales, and they failed to appear or they received a default judgment. You believe that you have a good cause and meritorious defense?
Yes, ma'am.
Okay, you place it on the record.
Yeah, so this was originally a small claims case. My client attended a hearing on this matter. The court ordered mediation. Actually, I think the mediation might have been prior to the hearing. Mediation did not resolve the case. The hearing did not resolve the case. But my client then filed to remove to general civil. That at that stage, I was made aware of the situation. And simply based on the case's history, and frankly, I don't do a ton of cases where I'm not the initiating party. I was under the mistaken impression that I would be receiving like a pretrial date based on the fact that this had already gone to a hearing. My client was clearly defending themselves and had appeared multiple times, both in mediation and in front of the court. And so I simply, again, was waiting for a pretrial date, then got the default, realized my mistake, filed this motion to set aside that default. That I guess that's a good portion, good cause portion of it, Your Honor. The other part, we did file within 21 days. I just want to make a note of that for the court. As far as the meritorious defense, I mean, this is based on a contract for a vehicle, upon which I think one payment was made. And so, I mean, I think my client can show evidence that there was a default of the contract by the defendant, or I'm sorry, the plaintiff in this case. And the issue is, they do have their vehicle back at this point, but have not been able to resell it. So I think that there actually is likely to be a counter complaint filed, but I don't know because they haven't resold the vehicle to find out whether or not there will be a deficiency balance. But regardless, it's a contract dispute. Ms. Scott seems to believe my client is in violation of the contract, in default of the contract. My client believes she's in default of the contract. And so that would be their meritorious defense to this case, which is kind of evolving, as I stated, because they have not resold the vehicle yet.
Okay, so I see this was originally a small claims matter, for breach of contract. Untruthful about car at the time of purchase is the nature of what is stated. And that it was your client, Mr. Credible, that had this moved from small claims to general civil.
That's correct, Your Honor. And there was a bit of a delay in that process as well, as far as my office being made aware. No fault of my client. but that occurred, and that's why, I mean, I think we waited maybe 20 days to file the motion after the default was entered. That would have been a shorter period of time. But again, sorry, go ahead.
I see a removal was filed on the 16th of August. Well, the 14th of August, but I see it was entered into on base on the 16th of August. I see on the 21st, we received an appearance. From your office, Mr. Fratterville.
Yes, ma'am.
However, I don't, a default looks like went in 3 days after your appearance. So the only delay I actually see is in between. If it's gonna be a delay, would be from the removal, which is the 14th. It took 7 days for there to be an appearance.
Correct. No, my what I was referring to when I said a delay is once that default was received by my office, normally I would have filed something like the next day. But there was a delay in actually my becoming aware. And so that's why. But again, Your Honor, it's within the 21 days, which I know is kind of goes to show that this was just frankly it was a mistake, and it was my mistake. And
I guess I need to know a little bit, I don't dispute that there's likely good cause. I think the mistake of thinking that there was going to be a pretrial after it was moved to general civil. I think that makes some sense since you all have been active in or your client at least was active in the litigation while it was in small claims. I think my concern now is just about the meritorious defense. This was a breach of contract. You're saying that your belief is that there was some fraud or what? I don't know what your claim is about without telling me in detail, just the general scope of what your claim is for.
Right.
You bought a car?
Yes, I received disability.
Okay.
And for them to release the money for me to get the car, I had to get, the statement. So the car that they released the money for, they end up selling it on me. They gave me a different car. And that car, when I got it, broke down 2 days later.
Okay, so breach of contract, you say untruthful about the car at the time of purchase. You had money released for one car and then they sold you a different car?
Yes.
Okay, and so that's what you said is the untruthful part?
That and lending.
Okay, and Mr. Federal, I don't understand what you're saying your client's meritorious defense to this is.
The plaintiff breached the contract by not making the agreed upon payments.
Well, her issue was that you all had fraud before we got there. What's the meritorious defense to that?
I mean, does she have any sort of documentary proof of those? I mean,
Well, she likely does, but we're not here for that. I'm here to know what your meritorious defense to the claim is.
I mean, her claims that there was something wrong with the vehicle. I mean, again,
That's not what I understood her claim is. Mind you, I don't have a complaint here. What I had was the small claims issue. And the small claims issue stated that there was, she said, some untruthfulness about the vehicle at the time of her purchase. And she just stated on the record, the untruthfulness involves money having to be released because she's on some benefits, that money was released for one vehicle that she was given this bait and switch, is what sounds like she got a different vehicle. And it sounds like you didn't agree to that different vehicle. Is that what you're saying to me?
Right.
Okay, so she gets another vehicle, that vehicle breaks down. So that's what she said her claim's about. It's not about her not paying for it. Why would she pay for the vehicle if what she's saying is true, if that's not the vehicle she purchased? So what's the meritorious defense to her claim?
I mean,
At least that's what she said her claim is.
Sure. I'm sorry. I'm reading I guess I'm reading the amended affidavit and claim. Sold original car that disability released funds for. Truth in finance is wrong. Amount of car per month. Car doesn't work. Said it was nothing wrong with. That's what I'm working with, Your Honor. But I guess I would say I don't know how we could give her the wrong car. There's a contract with the correct car listed. That she signed the contract. So anything that she's referring to as far as, and I understand what she's saying about funds being released for a particular vehicle. I'm not, I mean, I don't handle that day to day. Obviously my client would see those documents. I don't, she has a contract for a vehicle. So I guess that's why she would pay. As to whether or not her disability funds were specifically earmarked for the vehicle she's referring to, I can't speak to that. I don't have any of that in front of me. But I don't know why that would preclude her from purchasing a different vehicle. If she still wanted to go through with the
Let me ask you some other questions. What car did you purchase?
I purchased,
What car was the money released for? Let's ask that.
that's the one that was released for.
I just want her to tell me the car. I don't want to see any other exhibits. Well, just tell me what it was.
The one I got was the Jeep Cherokee.
No, what was the money released for?
It was released for the yes, the Explorer.
It was a Ford Explorer? Is what
Yes.
what you put an offer to buy on was a Ford Explorer?
Yeah,
What year?
2011.
2011? Okay, but you got a Jeep Cherokee?
Yes. A 2011 Jeep Cherokee.
Well, that's kind of different. What's the meritorious defense as to why she put an offer to purchase an Explorer? Money was released to purchase that, and then she got a Jeep Cherokee.
The meritorious defense is I have a retail installment contract for a Jeep Grand Cherokee that she signed and entered into of her own free will. So I don't have any documentation with the word Explorer on it. I'm not saying she's,
Okay.
I can't, I'm not refuting what she's saying, but again, what they released the funds for and what she contracted for may be two different things. I don't,
Okay.
if she's making a
Okay.
Truth in Lending Act, that's a federal, I mean, this is not necessarily the venue for any of that.
Okay. And you signed a purchasing agreement for the Jeep Cherokee, ma'am?
Yes.
And you knew that's what you were signing for?
Yes.
Okay, so then you did purchase a Jeep Cherokee.
Yes. And they
Okay.
told me there was nothing wrong with it. They
Well,
would put me in something better.
Well, that's a little different than a bait and switch.
Right. They said, no, there's nothing wrong with it. They'll put me in something better.
Is what they told you. That's salesman's language, yes?
Right. And, so when I purchased it, it shut down 2 days later.
Okay.
They were closed on a Sunday, so I had to call them Monday. They had to come tow it. And then it broke down 3 days later after they fixed it. And then it broke down again.
Okay.
And then they had it for a month.
So you're suing them for what then? I'm misunderstanding your complaint. I thought your complaint was that you bought one piece of property and they totally showed up with a different one and
Right.
you were not aware. So you were aware that you were getting a different
car.
car. It broke down and then what happened?
And,
Why are you, what's the suit, the lawsuit for?
so again, the truth in lending is wrong.
Can she elaborate on that, Your Honor? I'm genuinely
You're
curious.
saying the truth in lending is not accurate is what you're saying?
Right. Because you guys saying, the car would be like 16,000 and some change. Over here, it was 10,000. And I made a payment on there, so that took it down. And payments was said $422 a month, and the payment was wrong. It was only supposed to be 3.
So you're thinking that the accounting's not accurate?
Yes.
Okay, well, to that extent, he does have a meritorious defense. So I'm going to set aside the default, and this matter will be set for a pretrial.
Thank you, Your Honor.
Let me get you a date right now for the pretrial.
Okay.
I'm sorry. Pretrial can be anytime. Then we gotta settle down here. Pretrial. November 4th at 2:30.
November 4th, 2:30.
That's correct. And you don't have to appear in person for the pretrial. You can appear via Zoom. You just need video. Typically, what we do with the pretrial, if you're representing yourself, he's represented, Dice is now represented by an attorney. We put you in a private meeting room so that you can complete what we call a joint pretrial statement. It's a form that we've created so that you all jointly answer these questions, and that lets us know how we need to schedule. If you have any issues with completing that, or you feel uncomfortable completing it with their attorney, then the court comes in and I'll walk you through it. But most times it doesn't require a judge to participate. And then once we get that signed by both parties, that's when you get your deadline for discovery. Discovery is when you exchange documents and information. There may be documents you wanted from Dice to help you think will help prove your claim that you don't have. You can request all that stuff, or if you wanted to send what we call interrogatories, it's a set of questions. Those types of things are done during the discovery period. We're discovering what information is out there. We'll set the discovery period based on that time after the pretrial, and then we'll then set your jury or non-jury trial, depending on whether or not you've made a demand or make a demand for a jury trial. We'll set that after we get the pretrial date, okay? Do you have any questions at this time? We'll get you a notice to appear for the November 4th, as well as Zoom instructions should you elect to appear via Zoom. You can appear in person. Hopefully the temperature will be better in here that day. I don't know. We take it as we get it each day. So it's up to you how you want to appear. Any additional matters for the record, counsel?
No, thank you, Your Honor.
Okay, you're all set for today.
Thank you, Your Honor. Have a good day.
Thank you.
Thank you. Nice have a good day.
Same to you. Mr. Hintz, were you all set in the private meeting room?
Yes, we are, Your Honor. John Hintz appearing again for the Plaintiff Case Credit Union. Mr. James Trotter is also here, and he and I have spoken in a meeting room, and we have agreed for the entry of an installment order, Your Honor. We have agreed to the terms of an installment order being $150 every 2 weeks, beginning November 10, 2024. And this order, Your Honor, will suspend the periodic garnishment that was entered by this court on August 26, 2004.
Okay, that's correct, Mr. Trotter.
Yes.
Okay. Let me see. Might just be able to edit this one in the system. Okay. Let's see. Okay, I will edit the motion that was filed by you, Mr. Trotter, where you request to make installment payments of $106. We'll edit that to $150 beginning November 10th, 2024, that you'll make those payments bi-weekly, okay?
Okay, thank you.
No problem. Any additional matters for the record, counsel?
No, Your Honor. Thank you, Mr. Trotter. Thank you, Your Honor. That's all we have.
You're all set.
Thank you.
Citibank versus Roberto Flores, 24-04618. Anybody here on behalf of Roberto Flores?
Good
No?
afternoon, Your Honor. Andrew Cates, P78292 for Citibank.
Okay, I don't have anyone present for Flores. I don't know what this review was scheduled for. Let's see. I don't know, because obviously I would imagine that this was set before we had on base, so. And there's no note and we don't have a physical file. What was this matter set for review for, counsel?
Your Honor, at the previous hearing, we had agreed to a consent judgment without a payment plan. Our office mailed a consent judgment to the defendant on the same day that the last hearing was held. But we never received a signed copy back, and there has been no further payment or communication regarding this account from the defendant.
Okay, so how did you want to proceed, counsel?
At this time, Your Honor, I would request a default judgment to enter.
Default judgment going to?
The amount of damages claimed is $4,727. Court costs and fees of $124.41 for a total of $4,851.41.
Okay, that is noted. You'll file paperwork on my file to support
Yes.
that? Okay, you're all set for today.
Thank you, Your Honor. Have a great day.
Same to you. Okay, the record in the matter of Capital One versus Kevin Long, 24-063113.
Afternoon, Your Honor. Thomas Duquette, P 82958 on behalf of the plaintiff.
Name, sir?
Kevin Long.
Okay, today was the date set for pre-trial. This is for a general civil matter. Did you all complete a joint pre-trial statement, counsel?
I don't believe so, Your Honor.
Okay, do you have a device to get on Zoom? Okay, we'll get you in a private meeting room to meet with him, okay? Okay. Thank you. Are you waiting for something? She is. I'm not sure what she did. She's on the way, Ellen. No. The setter was supposed to meet with him. Give me your last name? Orange. Oh, yeah, because I still have the files from you.
Earlier, who said she hadn't met with him yet, but was going to, the lady that was here. No, she made some
She never said that. We need to let, contact her and let her know. Miss Oriens is still waiting and I still have the files. Did you send her? No, I don't think so. You help him get on Zoom and she will reach out to us. You help him get on Zoom, she'll reach out to the email. Okay, Mr. Duquette, did you and Mr. Long come to a agreement on the joint pretrial statement?
Yes, we have agreement on the pretrial statement.
Okay, are you gonna file that with the court on my file?
Yes, once I fill it out, Mr. Long wanted to take a look at it and be able to sign it himself. So I'll draft it, I'll get it over to him, and then once he returns it, we would file it with the court.
Very good. Do you have any questions today?
No, ma'am.
Okay, then you're all set.
Thank you.
Thank you.
Have a good day.
Thank you, Your Honor.
Thank you.